Welcome to The Debate. The legal ground underneath generative artificial intelligence is shifting very rapidly, and nowhere is this instability really more profound than in copyright. We are seeing creative works of, immense commercial and artistic quality produced by machines, often with minimal, if any, traditional human creative input. This reality has really blown a hole in centuries of legal doctrine.
Indeed. And I think the core dispute is whether these outputs, which can be purely the product of autonomous machine processing, should really be afforded the exclusive rights that were, historically reserved only for the unique intellectual labor of human beings.
And that frames the central defining question for intellectual property, certainly in the 21st century. Should copyright law be pragmatically reformed? Should we recognize and protect works generated autonomously by AI, primarily to incentivize the huge investment driving this technology and provide necessary legal certainty? Or, as you would argue, I believe, must copyright protection remain strictly limited to the creations of human authors, maintaining doctrinal purity, even if maybe it leads to some commercial chaos? So I'll be arguing for that necessary pragmatic protection, perhaps using the UK's existing framework as a kind of blueprint.
And I will maintain that copyright's foundational strength lies precisely in its strict requirement for human authorship. Major jurisdictions like the US and the EU hold this as a bedrock principle. And maintaining it means that creations lacking that distinct human spark must, by default, fall into the public domain.
Okay. So my position isn't merely theoretical. It's really rooted in what I see as unavoidable economic reality. The current legal vacuum across most of the world risks seriously chilling the adoption and, frankly, the massive commercial deployment of these sophisticated AI systems. If a company invests millions, potentially billions, into training a model that produces unique, high-value content, and that content immediately falls into the public domain, well, the return on that investment just evaporates. Protection is necessary, I believe, to reward the substantial investment made in the arrangements for the work's creation. The model training, the compute power, the iteration on prompt engineering, even if the final creative output appears machine-driven. And this is precisely why the UK approach, while unique, does offer a workable model. The UK Copyright Designs and Patents Act 1988, it contains a special provision for what it calls computer-generated works, or CGW. Now, this framework recognizes works where no human author can be identified, and critically, it assigns authorship not to the machine, but to the person who made the necessary arrangements for the work's creation. Now, for modern generative AI, that person is usually the user who, sets the process in motion. This pragmatic solution offers a necessary, albeit shorter, it's a 50-year term of protection, recognizing the commercial value being created.
I appreciate the focus on incentivizing technology. I really do. But that view requires, it requires sacrificing the fundamental purpose of copyright law, doesn't it? You frame this as a choice between economic viability and legal coherence, but I would actually argue that coherence is essential for long-term economic stability. The necessity of human involvement, it's not just a regional preference, it's consistently affirmed as a non-negotiable requirement across all major international intellectual property agreements and legal systems. Copyright protects the fruits of intellectual labor, right? Those creations founded in the creative powers of the mind that reflect the author's unique personality and their free and creative choices. That specific cognitive element is what we reward. When the U.S. Copyright Office refuses registration for works, they don't just cite legal statutes, they cite these instructive examples like the now famous photograph taken by a monkey or claims naming the Holy Spirit as the author. These examples establish a pretty clear historical and doctrinal boundary. If a work is generated entirely by a complex system without that necessary human intervention, that intentional creative leap, then it inherently lacks the human spark required for protection, and therefore it must remain in the public domain. Now, I see why you feel protection is necessary to recoup the initial colossal investment in the AI system itself, But let me challenge the economic premise underpinning the need for copyright here. The European Union has explicitly expressed resistance to introducing new exclusive rights for purely autonomous AI outputs. And their reasoning?
Well, it lacks a normative foundation, and economically, it might actually be suboptimal. Think about the underlying costs for a moment. Once an AI model is trained, the fixed production costs for generating potentially countless high-quality outputs, stories, images, code, are exceptionally low, almost zero, right? So if the marginal cost of creation is negligible, why do we need the immense, monopolistic incentive of copyright? Granting protection in this instance is, well, it's simply protecting a statistical probability engine. Copyright was never designed to reward systems that merely synthesize existing data points based on training data. It was designed to protect the genuine, non-obvious cognitive leap that arguably only a human mind can make. We risk granting an unnecessary monopoly over mere statistical synthesis, not genuine ingenuity.
Okay, I understand the philosophical distinction you're drawing there between statistical synthesis and the cognitive leap. But I think you might be underestimating the real-world market distortion that results if we cling solely to philosophical purity. The risk isn't just that AI creators won't be incentivized, the risk is the potential collapse of the content market writ large, which ironically affects human creators perhaps most acutely. Leaving high-quality, unprotected AI outputs available for free consumption, well, it risks the uncontrolled proliferation of functionally equivalent content. This saturation will almost inevitably lead to the devaluing of content across the board. I mean, if a marketing firm can generate a dozen high-quality, bespoke illustrations instantly and for free, why would they ever commission a human illustrator? The danger here is that this unprotected AI content crowds out human creativity because it acts as a perfect or near-perfect and certainly cheaper substitute for traditionally authored works. The CGW right, or something similar, is perhaps a necessary market hedge to keep human content economically viable by requiring protection for its functional substitutes. And returning to the pragmatic utility, the UK CGW provision, dating back to the CDPA in 1988, that computer-generated work system, it offers a clear statutory mechanism for assigning a claimant, the user who sets the process into motion.
Wait, I'm sorry, but I just don't quite buy that the CGW system is a functional model for today's reality. It seems to offer certainty at the cost of coherence.
But why discard a system that at least provides a path for incentives and clarity in the face of what could be legal paralysis? It identifies the party who invested the effort in the arrangement, thereby establishing commercial ownership. Isn't that valuable?
You're leaning, I think, a little too heavily on the history of the CGW provision. That provision, which was drafted way back in 1988, reflects a much earlier, frankly simpler technological context. It was primarily dealing with deterministic systems. Let me elaborate on that distinction just briefly. Deterministic systems, like an early computer program that followed preset, step-by-step instructions to generate a simple graphic, while they made the human programmer or user the clear author because they controlled every step of the output, essentially. Modern generative systems, however, are fundamentally non-deterministic. They use complex algorithms and massive training datasets to produce novel, often unpredictable results. The initial arrangement of putting in a simple text prompt today, it bears little causal relationship to the complex creative output you might get. So that 1988 legal concept just seems poorly suited to address the autonomy of modern AI. Furthermore, the CGW provision creates a fundamental legal paradox. It requires the work to be original in the UK sense, yet simultaneously accepts that it lacks human authorship. Originality in almost every other copyright context implies the stamp of human personality, those free and creative choices I mentioned. Legal analysts find this contradiction, well, deeply irreconcilable. The UK is recognized globally as an outlier on this, and even its own government has indicated it is minded to reject maintaining the CGW provision because, frankly, there's little evidence it achieves positive economic effects. International bodies seem much more focused on clarifying human contribution thresholds, not following the UK's path toward granting a short-term right purely on commercial setup.
That's a compelling technological history, I grant you that. But your argument seems to assume a kind of zero-sum game, where AI is either fully protected under traditional copyright or fully abandoned to the public domain. The reality is that the investment needs protection in some form, even if the CGW mechanism itself is perhaps imperfectly suited or needs updating.
Well, if we accept the premise that commercial value must be protected simply due to the massive investment involved, we don't necessarily need to leap to the UK's rather ambiguous statutory model. We might have better alternatives that maintain the human authorship standard while still acknowledging market realities. Look at the Chinese courts, for instance, which have demonstrated, I think, a much more nuanced, pragmatic approach. They have granted copyright protection, but only where sufficient human intellectual input was demonstrated. The key example people cite is the Tencent Dreamwriter case. There, the court recognized the human contribution in the selection, analysis, and customization process of the data, which was deemed significant enough to qualify for protection. Now, this approach differs fundamentally from the UK CGW, which assigns authorship merely based on making the arrangements. The Chinese model, arguably, correctly holds that the key distinction must remain control and creativity, which remains a human function, not just the technical setup of, say, typing a simple prompt.
Okay, I see why you think that the 10-cent approach is the ideal middle ground, but I think you might be conflating two different legal categories there, perhaps to avoid the harder question. The 10-cent Dreamwriter case, that sounds much more like what we generally call AI-assisted works, where a human demonstrably exercises sufficient creative control. For those works, the US and the EU already grant protection today. The human author is clear. That is not the difficult edge case we're really wrestling with. The true debate, I believe, is about the genuinely autonomous output, the creation where the human input is negligible, perhaps just a single word prompt, and the vast majority of the creative choices are, in effect, statistically synthesized by the machine. By denying copyright only to that autonomous work, we risk forcing the entire market toward inefficient legal mechanisms. Think about it. If a high-value autonomous output cannot be protected by IP, AI developers and users are then forced to rely on things like trade secrets to keep their systems proprietary, or maybe heavy branding to create a functional monopoly, or incredibly complex contractual controls to bind users. Those are all far less transparent, less efficient, and certainly more difficult to enforce globally than a clear IP framework like copyright. Denying a copyright might just shift the burden of value capture to these more opaque, costly, and less efficient legal tools, ultimately hindering market growth and technological adoption.
Who is entitled to protection? If the choice is between granting a massive, potentially destabilizing doctrinal exception just to support commercial efficiency, or forcing the market to use existing, robust IP tools like trade secrets or contracts, well, I maintain that maintaining the integrity of the copyright system itself is paramount. Copyright protects creativity, specifically human creativity, not just investment in proprietary systems.
So ultimately, my position rests on the necessity, as I see it, of recognizing the arrangement, the investment, and the profound commercial utility behind autonomous AI output. We must provide legal certainty, perhaps by adopting a framework like the UK CGW model, or maybe an internationally aligned version of it, even if it deviates somewhat from strict human-centric doctrine. Otherwise, we risk stifling innovation and potentially damaging the entire content market, human creators included.
And mine rests firmly on the foundational principle that copyright is intrinsically, inextricably linked to the human author, that bedrock requirement upheld consistently by the EU and the US. Allowing fully autonomous outputs to fall into the public domain maintains the coherence and integrity of the system. It reserves protection for the unique intellectual creation of the human mind. The commercial arrangement, the investment, that can and perhaps should be protected through other means. The creative spark, however, cannot.
The core conflict, then, seems to remain fixed between these two poles: legal coherence, maintaining that philosophical link to human authorship, versus maximizing the economic utility and investment return that seems necessary to drive autonomous AI deployment forward.
Precisely. And the central issue remains where we as a society ultimately choose to draw that line. Does the mere arrangement for creation, the setting up of the machine, constitute authorship worthy of protection? Or must the output reflect the human mind's personal touch, its control, its creative choices? There's clearly much more to explore in how these competing philosophies will reshape the very definition of creativity in the years ahead.